So this Justice Chamberlain guy, his name keeps popping up in quite a lot of court cases. He's quite a prolific High Court judge. I think this guy's criminal, this Justice Chamberlain. Now, what is this? This is the High Court judgment for this case. Baroness Jenny Jones versus the Met Police Chief, or the Met Police. Now, there's something actually that what we've got to understand here, right, is that there's sort of like an elephant in the room, or there's sort of like an issue which they don't want to talk about. Through this paper, they don't mention the word privilege once, right? But yet it is pertinent. They're trying to ignore its existence, right? And they're trying to do this through all of the Public Order Acts and all cases. They've got all these case citations, right? All these case citations and all these descriptions going into... They're nitpicking at the wording of the acts, right? Particularly when it comes to, like, if any person... would believe or would not believe there was a right, or if it would, obstruct or hinder someone else's right, or something like that, right? But the way these public order acts are written is actually to attempt to try to purposely undermine and ignore the existing privilege which may be in use. Not always in use, but may be in use, right? Which changes everything, because you can have it and you can use it, right? But they're trying to ignore it because, and I'm starting to realise now, it's actually since the Met Police were formed as a body, and the Crown Prosecution Service later on in the 80s was formed as a body, the implications of breaching this privilege are contempt, right? So, but the government want to try and control us assembling in public, right? Because they say that is the harm, or that is the bad. Persons assembling could be dangerous, right? So we need to control that with these acts. Yet, there's a privilege that can be in use and applied, which, if obstructed, it is a contempt from any other party, including the police. Right? Because the police cannot stop you from opposing, but they've actually become a body which can. It's like the government have given the police and the CPS sort of like a right, or they're trying to make out they've given them a right to politically oppose the citizens and be able to arrest the citizens. So that would be like making the Labour Party all police, right? And then when they're having an argument with the Conservatives, if they don't like what they're doing, they can just arrest them all, right? And the Conservatives can't do anything about it. That's effectively what they're trying to do, but trying to make out that it's all for the public good. Now, what I've realised in this, it's actually got quite a lot of important information, actually. And one of the most important pieces of information I found is through the Public Order Acts and various other amendments of other acts and updates. Apparently, they've tried to make out that, well, there's a pivotal point in this representation, and that pivotal point is they're going on the meaning of a public assembly. The meaning of what does a public assembly mean? Because this Extinction Rebellion event was multiple different groups, and it was like a big event over London, almost kind of like using the whole of London for like a Glastonbury festival, really, with different kind of events within an event, right? And they ended up arguing over that the police orders didn't specify the right terms to what they were actually enforcing, so therefore it wasn't valid. But in this, it does actually give a lot of case citations, and they're scrutinising the wording of the Public Order Acts and so forth. And what they actually do is that they've actually informed us that these acts, it was actually only a group of 20 people that they could like break up or write an order out to the police could write an order out if it was 20 or more people, and that it's almost it is giving indirect reference, a homage, or whatever you want to call it, an innuendo to the Tumultuous Petitioning Act, but they don't say that. But what actually happened is apparently that they edited the law or amended the law so that then they made it into two people. So, like, they're trying to make out that if there's two people, so that wouldn't mean that they couldn't do it if there's one, because obviously, right, you know, people, you can go out by yourself, you're not assembling. So they're trying to make out that, you know, two people or any two people. Now, if you're doing a petition, you know, by yourself, I think that indirectly, without confessing it openly, they've tried to make out that only one person. They're trying to make this so they could potentially argue that one person, right, theoretically could walk around with a petition thing and ask people to sign it. But, you know, as soon as that they ask one person and they subscribe to it, and they're in public together, that they could possibly even break those people apart. So you can actually get that person's signature, or they can come along with you to ask more people to sign it. They could keep you all separated as an individual, right? But you cannot form together. Now, the Public Meeting Act says that people have got a right to come together, transact information, and be there present, right, when it's lawful. Now, this is the thing about lawful. Are they harassing someone? That would be unlawful. But the thing is, if you're doing a petition campaign, you can't harass anyone because you can't be prosecuted for harassment, right? The effects of what you're doing cannot legally cause harassment on anyone, right? You can't actually be arrested or put in prison. Now, one thing I need to mention about this is that the one good thing about this, it has got one good thing in it, and that is that in one of the paragraphs they say that in this decision from this court, we're not going to touch on persons being arrested or imprisoned or the effects of that at all. Now that's the thing really that the privileges do. They prevent you from being arrested or put in prison. So if you are privileged and if you're using it, right, you cannot be arrested or put in prison, and that is absolute. So really what all these public order acts are about, if you acknowledge the core fundamental basis of the privilege, if they're using it, is that the police can't make many arrests and the courts can't put people in prison. So then it all becomes a matter of people management, managing people and moving them away from places or being able to break them up, right? And really, if you took that line of opinion, it would be almost like in this section 42 when they can't actually arrest children, but they can move them to a place of safety, right? But the thing is, if you've got privileges and if you are using privileges and if they're protecting you, anything that any other person does to intervene in your proceedings, if you're asking people to sign something or if you're trying to advertise it to them, right, canvass to them, the police are actually making a contempt, which is that's like Section 100 police canvassing, because they're trying to stop people, they're opposing the cause. They're actually stopping you from promoting the cause to other persons, right? So it is contempt, and in a way, I think that, I actually think that that's probably quite a serious factor, because, the police don't want to be prosecuted for anything, and neither do the Crown Prosecution Service, but when they're intervening in this, it's contempt. It's actual contempt. And that's why they can't do it. They're the criminals, not us. And what all these public order acts are doing are trying to make out that we're the bad people, we're the criminals. But really, if you are doing a parliamentary cause, it is always for the public good when the public support it. So it's never naughty, it's never bad. If the public support it, it's for the public good, right? Even I suppose, even if, things might get broken, if the public support it, then, it's like the jury are kind of agreeing with you, or some of the jury in a way. And you're only really removed from the common law all it's doing is removing it from the common law, because you've already gone to the public to ask them the opinion on it, and they're supporting it. It removes it from the common law. So, like in the High Court, because it's in the High Court of Parliament, it's not in the common law courts. This is the point, right? Now, there's quite a lot of things in this. They're referring back to the original Public Order Act, which is good. It's good because this is referring back to the original Public Order Act, but it does not choose to mention the role of the Attorney General to assist for political objects which may confer immunities. There's a little vague reference to it when one of the Extinction Rebellion people says that they had some lost property or lost objects or something. I don't know if that's coincidental or whether they might have known something about that original act or not, but I'm not sure. It might just be a coincidence. But it seemed that kind of stood out to me, like, yeah, but political objects, they're looking for lost property or something. I don't know how that ended up being in there. It was just one of the persons who happened to be doing a certain role for Extinction Rebellion. Now, to understand the situation with this, it's a little bit, in a way, it's a little bit like the Tumultuous Petitioning Act, and then you get the 1688 Bill of Rights, and they've got a little bit of contradiction between them, right? They had a bit of contradiction between them because the 1688 Bill of Rights said that you can't be prosecuted at all or put in prison for petitioning, right? But the Tumultuous Petitioning Act said that, you know, if you got over 20 people and you don't get permission, then that's an offence, right? And Herbert Broom said that the Tumultuous Petitioning Act was regarded as a bit of a joke, a bit of a, like, red herring, that after the 1688 Bill of Rights, it was kind of almost like laughable. But it's repealed. The Tumultuous Petitioning Act repealed. Not the 1688 Bill of Rights. 1688 Bill of Rights is still in force. So after the 1688 Bill of Rights, it's the fool who's made the Public Order Acts if they're not compatible with it. But this is the thing. When you read and study parliamentary law, they're fully supporting the whole basis and principle, right? And acknowledging it. But if you don't learn all the parliamentary law and only read the common law and read the acts, like the Public Order Act, it's not acknowledging it at all. And it's trying to make out that it doesn't exist. So you got these two separate things, right? And for the Public Order Act, these public assemblies, don't say public meeting, remember, public assemblies, right? And they even use the word protest. So they're trying to make it sound like even if it's political, the police have got the authority to break people up or arrest people. They never have the right to arrest petitioners, never, or put them in prison, never ever. It's not possible, right? But it's trying to make it sound like they can by calling them protests or demonstrations. But this is the thing. Sometimes it even says political protest, but it might not be a petition to Parliament or asking for action from Parliament. You can have political protest because what would, for example, if there's an election on, right? You know, what happens if people came outside the polling booth and said, blocked everyone from voting? That would not necessarily be a petition to Parliament because elections are recognised as separate from public petitions. But they're still under the parliamentary law of agency in that they've got certain functions. But since the 1868 Act allowed the courts to hear election petitions, well, that was what was going on under the Tumultuous Petitioning Act. They made an act so courts could hear cases, but then they repealed it, so now they don't. From 1986, from this Public Order Act, actually, when it was made, and the Tumultuous Petitioning Act repealed, courts actually do not hear cases of petitions. You do it directly with Parliament. They're not allowed to hear them at all, and you don't have any limit or cap on the people. Now, what they've done with the Public Order Act is they've tried to make caps and limits on people assembling in public, even though there's a Public Meeting Act. But the privileges exist, right? So there's a conflict there. Now you can have protests and demonstrations and public assemblies which are not parliamentary causes to the Parliament or Commons or Lords or the King. You can have them, they exist, and there's such a wide variety of them, right? All manner of different instances when you can have groups, bodies, people coming together, like, people having an open air theatre. It's an endless list, really. I mean, what if there's going to be what if the village want to have a meeting about whether they should have an arts and crafts fair, right? So there might be 30 to 50 people or 100 of an entire town might come together in the centre of the town, and they might, or in the town hall, and they might have a meeting, about whether they should have a craft fair, something like that. Now, the thing is that in the Public Meeting Act, doesn't say that it has to be outside or inside, but the Public Meeting Act, in this, that they're trying to make, that they're not actually proving it, but they're trying to they also would like to be able to gesture that, because it's outside, it's not a public meeting, and you don't use a Public Meeting Act, right? It's just a demonstration or a protest, right? And that the public meetings are for indoors, but they're not. Nothing in the Public Meeting Act says that it has to be inside, right? So that they're also ignorant of the Public Meeting Act as well, and it's definitely lawful when you're using privileges, and that cannot be broke up. Now, the way to solve this is that you need to understand the William Penn trial. You need to understand the William Penn and William Mead trial, and you need to understand the irony in it, right, in that 1661 Act. You need to understand the 1661 Act. So, the 1661 Act, up to 20 people can be privileged, right, without question, right? Absolutely, even before the 1688 Bill of Rights. Before the 1688 Bill of Rights exists, right, you can have 20 privileged people, because that's what it is. You've got a case to Parliament, right? You're following a parliamentary cause for the usage of Parliament. And an MP could write you out a writ of privilege, right, if you got into any legal trouble, but the petition itself is meant to protect you, right? Because you're doing it. It either exists or it doesn't, right? Now, because of mischiefs, right, and larger numbers of people getting involved for various reasons, they put a cap on it. Now, this what they did in 1661 is very similar to what they did in 1868 with the election petitions in the courts. Like I said, right, election petition is going to be heard in the courts now, right, or they can be heard in the courts, right? I don't know if the 1661 Act was lawful, because Parliament has the right to decide its own affairs, right? Not the courts. But courts can check if people are privileged or not, because if you had 20 people who were privileged, you might end up getting challenged in court over it, but then you could claim the right. Like now we've got overriding objectives, so you just say you might end up in court and get challenged, but you just claim it, right? And then it's valid. Parliament, only Parliament can hear it, but obviously the court have to hear the claim if you're challenged, because, you have to tell them, right? So, it was, people were assuming privilege and using it, but they wanted to try and make sure, in a way, it's sensible, because then you can get it all checked out and get all your papers together, right, officially, and then they want to know what you're up to and what you're doing, and get a check on it, right? But once you got that order, you're allowed to attach more than 20 people. So, they don't all have to be... Well, they're going to be named when they sign it, right? They're going to be named when they sign it, and or if they're canvassing it. Because if they're canvassing it, then, what are you canvassing? It's right. It would, if you're selling... If you're in a market shouting, buy some bananas, right? You're selling bananas, okay? You're not selling, pork chops. That's the argument, right? If you're advertising a petition for this or that, that's what you're doing, right? I mean, or if people are signing it, you're not going to get misconstrued for doing something that you're not doing, and that's what you prove, right? Are you selling bananas? Yes or no, right? This is the thing. No, they're pears, right? Well, you can't have that then because, it's for bananas. This is the thing, right? It is what it is, and it's not what it's not, and that's it. But obviously they wanted to get some kind of they wanted to get some documentation down, really, so, that people knew what was going on. Really, that's sensible. But definitely officially, when you're attaching privileges to people and it starts getting, a large number of people, it's quite serious. So, you got to, it's official. It makes it official, right? Not just like someone was making it up. It's definitely, this is official, right? That is officially being done, right? So, you can have large groups of people attaching privileges, right? Now, the problems, obviously, the Luddites smashing machines up. Now, if you're at work and you're just working and then you go up to the workplace in the middle of the night and break in and smash machines up, right? Is that promoting a political cause or not? It's like canvassing, or are you just breaking things, because you're annoyed? This is the thing, he's pushing it to say that it's, a promotional thing or just an advertisement, right? And this is why the government don't like Extinction Rebellion, because they're very, very, they're filming it and taking photos and they're making it into an advert, or they're doing it for an advert, just like a movie, really. It's out, it's about painting signs, words, letters, notices, and it all can be construed under the Town and Country Planning Act, right? Obviously, if it's on privately owned buildings or land, you've got different implications there because it's not publicly owned. When it's publicly owned, you get automatic consent. It's the private property in private land, but a lot of shops and things like that are on public streets, and public access bus stations, things like that. But are you protected from prosecution, or can they bring civil arguments, or what? But there is a certain amount of protection and privilege which hasn't been recognised and should have been recognised. But this is mainly about people just being able to come together and form groups, right? So now, 1661, and then we get the Bill of Rights, right to petition, and then we say, right, no one can be arrested or prosecuted for petitioning. Well, you say, what about if they had a tumultuous assembly? Well, how did that work? How did it work in 1688 if no one can be prosecuted or arrested for petitioning, right? People got the right to do it, but there was a law saying that if over 20 people do it, that's an offence, right? I don't know if they got them into the court, and then if they could prove that they were doing it, then they weren't prosecuted or arrested. Now that's I don't know how you can hold this in your mind, but the irony in the William Penn trial, it's like I think it was because they were Quakers, right? It was because he was a leader of the Quakers. He was a leader of the Quakers, and they had to have their their meetings in the streets. But it's like matters of church, state, or law. So it was matters of church, right? And they wanted to have their meetings in the street because they couldn't have them inside. So it was to do with that. And so it was a tumultuous assembly for matters of church, right? And the thing is, if you're doing matters of church, state, or law, you're meant to be privileged, because remember, priests who were holding sermons and so forth had privilege from arrest when they were doing service, right? I forgot about that. That's the first time I've mentioned that when I mentioned the Tumultuous Petitioning Act. If you've got a leader of a congregation, which is a religious order, particularly if someone's ordained or not, they can't be arrested when they're doing it, can they? Remember that? So that's another privilege as well. I just remembered that one. I just realised it. But but the thing is that the jury said they weren't doing a petition. Now, this is the thing. This is like the Public Order Act, right? In the Public Order Act, right? If you're not petitioning to either houses, then you ain't got privileges, right? So you can be arrested. But if you are, you can't. But the thing is, if they were doing an assembly, which was privileged, but that was the offence too. So that was the irony, right? That doing something that you can't be prosecuted for was the offence. So that's the irony of the Tumultuous Petition Act. But I don't think it was really that much about punishing people, although reading the Sam Sterling proceedings is quite it's quite a messy, nasty proceeding in that court. Although it might have just been the language of the time, I don't know. But they were just saying that they didn't have any rights, but they 1688. Now the thing is, all the way through all this, to the unsuspecting person or to the unknowledgeable person, there's a law, right, from, it's like from Magna Carta, 1215 or 1297, very, very early, literally not long after Magna Carta. Although the Liberties of London is the oldest law, the Liberties of London are older than Magna Carta in modern law, or in law that we've got that is not like Edward the Confessor's laws. The Statute of Westminster II, that Statute of Westminster II is really important, actually. Could possibly even be more important than Magna Carta, because that says that if any justice is disregarding any law or a right, a point of law, you can complain to the king, right? And say what's going on here, right? So that your right to petition the king starts actually from the Statute of Westminster II, because everyone's got the right to complain to the king for a proper investigation. If it's a matter, if the judges are lying about the law or not upholding your rights, okay? And you see, with the Tumultuous Petitioning Act, you would be able to do that as well. Now, if you had a group of people, right, like over 50 people who hadn't got permission, like William Penn. Now, William Penn could actually have put a bill of exemption to the king, and said, we have got the right to do a congregation without being arrested. Okay, because that's a legal point of law. Now, it was an offence to not get permission, but the irony is that doing a congregation for a religious ceremony is not arrestable, right? And you could argue with the king on that, right? So and you could, in 1688 Bill of Rights as well. Now, this is why Sam Sterling's going on about this. I'll put my mark on you. I'll put your mark on you. No, you put your mark on that complaint. You put your mark on that complaint, and I'll send it to the king, right? This is the thing. But they didn't do that. They did this other thing, which they hadn't. I forgot the name of it now, but it was. They've got this other form of appeal, right? It's a fancy French word, right? They got this other form of appeal, which they went through to get it sorted out anyway. But they could have complained about Sam Sterling there and then. So the right to petition actually comes from the Statute of Westminster II, the right to petition the king, straight through. But it was the 1688 Bill of Rights itself, its shape and form and its layout is almost like William Prynne wrote it, because William Prynne wrote a paper which is extremely similar. It's not identical, but it's like laid out very much like the Bill of Rights with the same things in it, about all the standing armies and all this and that, because of all those soldiers that were around using martial law at the time and going in people's houses, and you were protected by martial law and so forth. It's almost like William Prynne, almost kind of like. It's almost like in 1688, William Orange. Well, it's called William Orange as well. William Orange, William Penn, William Prynne, right? So, it was already kind of like someone already kind of like had the idea for it, right? And after 1688, definitely, I think it affirmed and upheld that the 20 people definitely would have protection, and then also if you get the court order, then it definitely is properly a thing, right? So, a lot of people were pushing like the Luddites pushed the boundaries, and the suffragettes are pushing the boundaries of it. I think all the time people are pushing the boundaries of it, right? But it definitely exists and it's there. Now, when we got this, after this Luddites thing and they're pushing the boundaries, smashing the machines up, right? You've got like, the Reform Act and all this. So the same is happening with how the elections are running away at the same time. But this Parliamentary Papers Act is important, and Parliament burns down and all the petitions are burned, remember. The Parliamentary Papers Act is important because it gives protection. It can be used. You could use it. I don't think anyone's been bothering using it, but it was made, and the formation of the Met Police, right? So coming back to this paper, which I haven't been talking about. I've not been talking about this paper for a while since I changed subject. So this paper. So this is where these people, they're a little bit, they want to ignore privileges and they want to ignore contempts. They don't want to raise that and acknowledge it. And I think that that's intentional. So we've got the Baroness and we've got the High Court judges and some of these MPs. They don't want to acknowledge the privileges. They purposely are ignoring them like the elephant in the room. But at the same time, then they don't know quite a bit enough about the first Met Police Act and some other little bits of the law, right, which make the whole thing make sense. So, and I think that they don't really. I don't know if we're being betrayed by the barons or not, but it's like they're holding something in their hand and holding it behind their back, right? It's like when someone holds something behind their back and hides it from you. It's like they're going through these proceedings and they're purposely kind of hiding something from us. But if they knew the rest of it and the full legal law, it would compel them to not hide it behind their back, if you see what I mean, and they will not be stupid enough to try and hide it behind their back. So they're sort of they don't quite know enough, and they don't know how stupid they're being, and they don't know how dumb they are, that they shouldn't be trying to mislead us, but they are misleading us, and they kind of know they're misleading us, right? So it's that sort of situation. The first Met Police Acts, following on from the Bow Street Acts, makes the law for the Met Police and all the offences. And it states in those acts that people shall have their privileges, including the privileges of London, and shall apply as if those acts were enacted. So that's it. If the privileges are being used, like an Erskine May at that time, you've got all your Erskine May books as well, right? It's as if those acts don't exist, right? So, those offences don't apply. Now, the thing is, you've got offences like, causing a nuisance in public, putting placards down the road, using foul language and stuff like that. So if you're using privileges, those things don't apply, right? That's it. Because, if you are going to be punished, it will be by Parliament, right? Not by the common law in the courts, not by the jury or public, right? Because it's the High Court of Parliament that your case and causes to. You can be punished by Parliament if they're going to or not, but 1688 says that you can't be punished or can't be prosecuted. So, it's all the definitions of what is petitioning, and that's why you need to learn, okay, what does this entail? Well, we know it entails canvassing, because you need to do that And this is why the control of advertisements, town and country planning was made. It fully, completely and totally and utterly provides and facilitates for that canvassing, even defines advertisements and says that you can use any act of law, right? So, even representations in public, digital screens, you can even use theatrical representations really under that. So this is where the Extinction Rebellion stuff's coming in. Now, the arguments are only, when they start breaking or smashing private property, not public property, and damages, should they be criminally prosecuted or are they immune? If it is an advertisement, hybrid sort of advertisement that breaks something, can the private people bring civil recovery? Now, the Parliamentary Papers Act protects the effects. It protects anything that you say or do, right? The effects of that. So like defamation, libel, harassment. These are things that are anything emanating from the petition campaign or canvassing, right? Anything that comes from it and affects people from the speech of it or from the advertisement of it, like, is protected from the common law. Now, does that go on to physical stuff as well? Well, we know that advertisements, it goes on to like nails and hammers and sellotape for fastening signs because you got consent to put them up in public but not in private. Now, this is where your Department of Transport building is pertinent because it's public building, right? Department of Transport building that Gail Bradbrook, climbed up and did an exhibition on the top of there and smashed the window, right? That's public property, right? It's not private. So, you're right you're on the threshold boundary of, what is legal or not. But none of these arguments were argued. What I'm saying now is what should have been argued, in the same way that all this has got into very, very technical arguments about the Public Order Act, like and lines and paragraphs of legislation are being scrutinised. They're not scrutinising the lines and legislation of the Town and Country Planning Act. They're not scrutinising the legislation of the privileges. Now, mainly because if it's privilege, they're not allowed to in the court, right? The court can't argue and debate and hear the case, right? So in a way, it's ironic that they can't. If it is privileged, and then you usually claim your privileges first, that it is always not for political parliamentary cause, you can't really have the argument in the courts on the technicalities of the control of advertisements. That's the irony of it, really. But maybe you could, you could mention that as part of your rights claim. Say, I'm privileged. I'm using this right, and we're saying that it extends this far, right? But that wouldn't be a defence. It would be trying to say that the right extends this far. Courts can determine if a right applies or not, but they're not doing that. They're not actually doing that, and that's upsetting because I'd love to read one of these papers, which was having the debate on the control of advertisements, but they're just not doing it. They're not interested. They just do not care. Don't know if it's because Extinction Rebellion won't listen. They won't listen. I don't know, they're not getting the right lawyers in the right area of law. They're always getting criminal lawyers or public law. Well, it kind of comes into public law, but they never get the act out. It's usually only in local council disputes. And in the act, it's only a fine anyway. It's not criminal. And that proves that it shouldn't be a criminal charge anyway, only a fine if it's not consented, really, I think. But normally is consented. Now, coming back to the Public Order Act, so we've established that the Met Police says that privileges apply, people's privileges apply, right? Including the privileges of London, like Londoners don't have to pay for tolls and stuff like that, like if you go through a toll without paying or something like that, right? And there are other peculiar privileges of London as well. So when we get to the Public Order Act, privileges are already in effect and apply with the 1688 Bill of Rights. And then and this is what there's a little bit of an allusion to they say in this. I mean, I should find a little bit where they say it, but they say, before the Public Order Act, 1936, public meetings, there was little control to them. No, there was a little control to them. He was fully privileged. If it's a petition, you can't be prosecuted, right? But they were controlled, because remember, you had to go to a court. So you just didn't have, if it was privileged, over 20 people, right? It definitely was. It was officially privileged, attached. So you wouldn't have an assembly of over 20 people at all that was privileged, unless it came with a court order. And if it didn't, it wasn't truly a petition, because then it would be illegal. So it would be illegal anyway, if you haven't got a court order, right? It would be illegal anyway, because you didn't go through the proper process and procedure, right? So this is the thing. It doesn't really matter whether people are canvassing it, because they're still kind of like putting their hands to helping to promote it, right? Even if they didn't sign it. This is the thing. You don't have to sign it if you're putting your hands to it. Like, if you're sharing it, really, you're kind of helping to support the cause. Even if you don't sign it and support the cause, you're still putting your hands to busying with it, really. That's another argument you could have, whether canvassers are really helping the cause. They might not support the cause, but someone might have got them to help them share it. But why would you help someone share a cause if you didn't support it, unless you're only doing it for money? But then it's still, you put your hand to the paperwork, you're carrying it around, even if you're not signing it. That's another argument, actually, a good legal argument to have, I suppose, that. So this is when the Public Order Act comes into check. So the Attorney General's met a check, because elections as well. For elections, the special protections, political objects. Now this is where the ignorance comes in, because they knew that, but a lot of people just just through negligence or lack of knowledge, and then they wanted to, particularly with minor strikes and things like that later on, that they're wanting to kind of make out that you can have a political protest or a political demonstration that is not privileged and doesn't use privileges. Well, you couldn't really have one unless you had permission or consent, really, up till 1986. So those earlier Public Order Acts, you could have them, which were completely and totally privileged. So this is lying a little bit, because he says, they weren't very tightly controlled. Well, no, you couldn't actually control them at all whatsoever if it was lawfully privileged. Officially, you couldn't control it at all, because, you can't arrest people or prosecute them, for sure. So it's ironic in this, they say, we're not going to talk about arrests or prosecutions, only about, the right to assemble and come together. Well, under the Public Meeting Act, when it's lawful, and if you're privileged, it's lawful, you've got the right to come together and you can't be broke up, so the police can't break you up. So you've got that. And then as they're doing these Public Order Acts, they're bringing all this language like protest, demonstrations, and they kind of just want to ignore that. But yet it's still in effect, the first one, right? And the Attorney General's just like, said, like, bollocks to this, basically, we're not going to bother doing that. But yeah, it's the law. And then after the Crown Prosecution Service was formed, wouldn't it be great if all these people were privileged and we arrested them and then were in contempt, right? Well, no, we can't have that. We can't have Crown prosecutors being done for contempt if they make mistakes and arrest or prosecute petitioners. And what about the police doing it, If these large groups of people are privileged, the police all have to be the ones who are arrested themselves. So there's good reason for them to, we won't associate the Public Order Acts with this thing called privilege in Parliament, which is, well documented and talked about when you get into those books. because it could be problematic for the police officers, right, and the CPS, and we don't want our police officers and Crown prosecutors getting prosecuted for contempt, right? And also, it would be good if we could control these people, right? Even though they might be privileged. But yeah, so why didn't they just, scrap it from the parliamentary thing? Well, because of tradition and because of honour and because they don't want to lie in the parliamentary books, it's been continued through them because that's what the law is, if you know about it. But they did eventually start to try and comb it out gradually and not talk about it, but when it still exists, when we got into the Malcolm Jack and later books and the Manual of Procedure in Public Business from 1986 and around that time, Margaret Thatcher, they did start to comb it out of the parliamentary side of it, but they can't get rid of it because it exists, right? And it's in the constitutional law. So they separate it, and then they just dim it and die it down, and they change the language a little bit in the Public Order Act to make it sound like this must apply to all and any possible public meeting or assembly, even if it's two people. It must apply. Well, no, actually, it must not apply. If it's privileged, it cannot apply. Does that exist? Well, actually, it does exist. But not a lot of people know that because you've been pulling the wool over their eyes with your language in the Public Order Act, making it sound like it's not just football hooligans or music fans or people coming together to organise a craft fair in the village, or loads of foreigners, running around riot, or whatever, or a kindergarten party. What are they going to do with the kindergarten party? Going berserk when none of the kids can be arrested. Things like that. But they definitely try to pull the wool over his eyes, and that's basically when we get to this. So that they're scrutinising all these complicated technical details about the meaning of public assembly and other criteria and wording through those acts, but they don't, but they've also admitted that it's a parliamentary cause, officially recognised parliamentary cause with a parliamentary objective, and people can't be arrested or prosecuted, right? But they don't want to talk about arrests or prosecutions in this paper. Ironically, it's only about whether or not the police's order was lawful or not, and because it was worded a certain way, it apparently didn't apply to all of the things that were going on, right? But what a shame we didn't pull the privileges out and say, oh, well, actually it's contempt and the police officer's in contempt. But no, we're not going to do that. We're just going to say that there's some technicalities with the police's paperwork, right? And that's where we are with it now, basically. But this actually isn't to do with Extinction Rebellion breaking anything or painting anything or climbing up on anywhere. It's just the fact of them coming together as a group, like we public meeting acts and so forth. And I don't think they can do it because if they could, the police theoretically could stop people from going to a polling station, or if they wanted to, as a body, and just take over. But they can't do that because it would be like the Conservative Party being the police and the Labour Party not being the police, and then them like just arresting them all, and if they wanted to, and stop them from meeting, you can't do that. When you got a political opposition, it has to be, and that's what parley is all about, to talk, parley. Now, you might say, well, Extinction Rebellion aren't talking, they're smashing things up. Well, the thing is that, under the definition of advertisement now, which they're not arguing over, they should have done, it can qualify, as, parley is a representation in public, an advertisement. And that's the thing, they're pushing the boundaries of what an advertisement means. And instead of arguing that in court, which is what they should have been doing the whole time, we've had 2019, 2022, 6 years of evasion of that. They don't want to argue about, the definition of advertisement and, representation in public. They don't want to argue that in a court. I don't know why. And then, is that privileged or not? But for separating people, I just can't see how they can do it, because, Public Order Act says that if it's lawful, you can't be separated or stopped from transacting information. And if you're going along trying to get more people to follow it and come to the meeting and interested in the petitions, right, privileged. And then the Public Meeting Act prevents you from being broken up. So the Public Meeting Act, a Privileged Public Meeting Act, Parliamentary Privileged Public Meeting Act, can't be broke up. It breaks the Public Order Act, really, and it means the Public Order Act can only really be used for, football hooligans or, randomly occurring riots or shop looting or something that is not promoting, canvassing or advertising a political cause reasonably under, representations or advertisements in public, which are identified, but they're not arguing that. I wouldn't mind if the police chief was in there saying, this is not an advertisement, this is not canvassing, but he's not. He's just saying, these people, just for the fact that they're coming together, we're going to break it up. But he can't do, right? If it's for that purpose or reason. And my opinion is, tending on these powers of those acts, the Public Order Acts is more like management, event management, really, without arrest. If it is a parliamentary cause to Parliament, then they can't be arrested or imprisoned. But, so what do they do? Is it a contempt if they interfere with that? Well, it depends. It depends what the police, it might be the protesters challenging, if the police blocked them, then maybe it should be the protesters prosecuting the police, and in court, was this a contempt or not? Did the police block them or not? And did they have the police the right to block them or not? And that would turn it the other way around, because it's all like the police against the people, the police against the people, the police against the people. It's never like, we weren't smashing anything up, we weren't breaking anything. The police didn't have the right to write this order, or break us up. They're the ones committing the contempt, right? And being prosecuted. That's what the Attorney General's meant to do. But, Extinction Rebellion never seemed to get a private prosecutor, and then again, should it even be prosecuted in the courts? Contempts of the High Court of Parliament maybe going to be heard by Parliament, but the committees aren't set up to hear them. The committees aren't set up to hear contempts at the moment, and the current MPs for the current parties are all like, they're all like soft, they're partisan, they're biased, right? And they don't really want to bring that to the public attention, and they just don't want it to be. It's like, it's back to this position again of holding something behind their back in their hand. They don't want people to know about it. They don't want to have to have a contempt case against the police, because they just can't handle that. They just can't take it. And this is why Parliament aren't fit for purpose, just because they just won't do things properly. And this is why the election petitions were extended to the courts. Is that even lawful? It's High Court of Parliament. Is the election petitions in the courts even lawful? Who can afford to pay for those privately now? The CPS aren't bringing them. I think some offences the police can be called, but the Electoral Commission don't. Nigel Farage has broke the law. I think Lesfer McVeigh has broke the law. I've complained to Michael Grade of Ofcom and explained to him that, it's not the BBC fully funded. It's like there's a lot of money gone into these private programmes, which is it's gifted, and some gifted money goes into Rees-Mogg's pocket, and it comes to us in the package of a political influencer as entertainment, right? So even the election, I don't know whether the election should be heard in the courts. No one can afford to have it. And now, when people are calling people out for dodgy elections with social media, you're racking up a lot of signatures. It's not one person. Oh, this is my election petition. Here's the money and my evidence. It's like, no, here's 3 million people saying that, the entire party broke the law and misled people, not just one candidate, and why aren't, well, where's all your, where's the £1,000 shared by 3 million people? Well, that's less than half a pence each, or, it's like not even a pence each. So, I don't know how you share that money cost between them. And then the court's going to be like, we're not going to hear 3 million witnesses. It'll take us, 100 years to hear the case if there's a 3 million witnesses. So, is Parliament going to even hear it in a committee? They're not even set up to hear it. And because they don't have, they haven't organised themselves for it this time. And, if 3 million signatures doesn't get you a public inquiry, I don't know what does. I think Hillsborough got a public inquiry with less signatures than that. If 3 million signatures these days doesn't get you a public inquiry into something, when, regardless of what they're asking for, we want a general election, in that request is some evidence of wrongdoing and great public concern about it. If one of the ministers doesn't say this might justify a inquiry against the Labour Party, I don't know what does, other than the fact that it's the Speaker who would have to put an investigate or authorise a committee or investigation. Actually, a minister might be able to have a public inquiry without the Speaker, but to have a proper traditional election petition investigation in Parliament, the Speaker puts a committee together. Labour members won't be able to vote in it, from what I've read. And the Prime Minister's Labour as well. With a Labour Prime Minister and a Labour Speaker, the prospects aren't good. But then again, like I said, if 3 million people sign something and you don't get a public inquiry out on it, then what does get you a public inquiry? Into whether they misled people in their general election campaigns or not. Who's going to find out? And actually, I think if they had a public inquiry into whether or not Labour Party did misrepresent in their election campaigns and then do the complete opposite in Parliament, I don't think it would be Labour. I think they can appoint people to the committee and the board, like Professor Tim Wilson or something like that. It could be the chair of it or whatever. They can put people in like that. Sir David Attenborough or something, could be on it. If they choose people who aren't particularly affiliated with Labour or the Conservatives, they could do that. There are people, there are competent knights, possibly judges. But this is the thing, are these judges affiliated with political parties who are doing this here, So that's my scoop of it at the moment. There's a big elephant in the room with the privileges part of it, which, when used with the Public Meeting Act, you can't break these things up. And the truth about the Public Meeting Act is that it's really giving the police permission to do people management, right? But if they're not hooligans, and if they're not, having if it's not a meeting of whether the village should have a craft fair or whatever that went bad and into a big dispute or something, or otherwise, you just can't arrest them, right? You can't arrest them. They can't be arrested. So what can you do with them if interfering with them is a contempt, right? Or could be, and they could actually prosecute the police for contempt. Well, the police have to, think about what they're doing. And you're definitely on the picket line with that. Then you're sort of like, you know, and, you know, maybe at that point the police want to think, you know, do I really want to be a police officer? But, you know, the heroes, remember, the police officers put their life on the line to protect the public, you know, they apparently, like, you know, firemen and ambulance drivers, you know, it's all right when a police car races down the road at 100 mile an hour saying, you know, here I come to save the day, putting my life on the front line. This is the thing, they're getting all these medals, right, and all these awards and pats on the back, and they're all having parties together and line up the troops, polish the boots, get the ceremony out, you know. This police officer rescued Rapunzel from the tower, or dived into a pond and saved a drowning kid, or whatever. And then another police officer, you know, he got himself put in prison for 3 years for contempt or whatever, for arresting protesters. But, you know, he's a hero now, you know. And this is the thing. Extinction Rebellion are going to prison, and they're making, like, martyrs, heroes out of people like Roger Hallam and so forth. In fact, you know, one of those, I think that someone died in prison to do with one of the Tommy Robinson protesters, I think, died in prison, you know. You know, where are the police? You know, where are the smirking police officers, you know, and arrested 5 protesters illegally? And, oh, here he is in prison, you know, PC plod, you know, here he is, you know, get him up on the police thing. And then you know, why don't you get the police guys giving him a trophy going, yes, you know, he put his life on the line to protect the public, even if he had to put himself in contempt. You know, this is a thing, but to them, they don't want to look bad, you know, they want to be the heroes doing the right thing, but they're actually, you know, breaking the law. This is the thing, right? But they don't want, you know, they don't want the Roger Hallams of the police force to, you know, where's the police laughing about it and cracking the champagne out? Yeah, you know, here we go, you know, 5 officers illegally arrested these people, putting their life on the front line, you know. Well, actually, they're breaking that's it, you know, good one, officer. Breaking the constitutional law again, you know, here he comes, you know, hands in his pockets, coming out of prison. Yeah, the constitutional law breakers, you know, and then the police cracking some champagne open and having a laugh about it. Well, this is what we do, put ourselves on the front line to protect the public, you know, take away the constitutional rights. This is the thing, right? Well, where's all that? They don't want to admit that they broke the law, that they did it wrong. You know, this is the thing. They don't admit that they broke the law as well, you know, for what they believe in. You know, we believe that, you know, these people shouldn't be protesting, even though it's a constitutional law. We oppose this law. It's like our little protest, you know. We're doing a little protest and getting ourselves arrested as well, but only that, you know, we're doing our little protest by arresting them, but we're not getting arrested, you know. I think George Monbiot was involved in this, you know, so I'm quite surprised Monbiot hasn't raised some money to prosecute the police for contempt. And that's just a problem. You know, you can't get Jonathan N. Fuller or Monbiot to listen about privileges, or to them to do any arguments around the Control of Advertisements Act, technical arguments like in here about what is or is not an advertisement. They just want well, I don't know what they're arguing about. They're arguing about that Public Order Act. The thing is that Extinction Rebellion and Monbiot and, you know, the Good Law Project, and they're all sold on this misleading wording of the Public Order Act. Like, they think that it applies to all political actions and there's no such thing as privilege, right, at all. It doesn't exist. They've been sold on that lie. Like, they've had the wool pulled over their eyes on that point. But yet it exists, and when you apply it, it's fully compatible. I think it's when they use the word protest and demonstration, right, that what that actually means. And, like, I think when, you know, they throw the word in political protest, they're sold, or they're bought. They've fallen for this kind of like, oh, well, it must mean that there's no such thing as a political protest, that, you know, you cannot be arrested for them because they've just said that you can. You know, yeah, it's not the Tumultuous Petitioning Act. That's the thing. The Tumultuous Petitioning Act was like, if you go to court and get consent, you can't get prosecuted or put in prison. Unlimited people, right? You can't, right? So, if it's matters of church, state, or law, to petition. So that's it. Now, that's repealed. It hasn't repealed the privileges, and it hasn't repealed that you don't have to go to court to get permission, right? You don't have to go to court to get permission, right? But who's attaching the privileges to it and officially claiming them? Well, you're meant to do it yourself. You might say, just hold on a minute, you can't arrest me, right? Or ask Parliament to help with the Parliamentary Papers Act, or whatever, a privilege or something. But they're not doing that. Instead, you got this Green Party MP, this Baroness Jenny Jones, coming out with all this complicated common law jargon around the Public Order Act. But she's a member of the House of Lords. Like, get Parliamentary Papers out. Where's the Parliamentary Papers Act? Get it out. Where's the privileges? So we don't know whether she just doesn't know about it, or whether she's helping to cover it up, a bit of both. But what I do know is that the MPs don't even really know about their own privileges properly for themselves. Like Dan Norris, Suella Braverman, and Mike Amesbury, because they're not meant to be arrested during Parliament time, during sessions, but they have been doing, and definitely not for summary offences. You can't proceed with a summary offence during Parliament time. Only a felony, because felony was serious, and usually actually perjury, contempt, and treason were all prosecuted by Parliament or at Westminster Hall anyway, not in the courts. And they've abolished felony, but when they abolished felony, they said that, well, what do we do with it? Well, it's just to be treated as a misdemeanour, right? And the misdemeanour couldn't be prosecuted during Parliament time, right? So from 967, really, how they should have been doing privileges according to the 1770 Act is you have to wait till the end of the session, because they said that, well, all felonies are only misdemeanors now, right? That's what they said. They said, oh, from now on, all felonies are only treated as a misdemeanor, right? So that means they have to wait until the end of the sessions. The privileges of Parliament for things that aren't under the Article 9 of the Bill of Rights, which are matters and affairs that were Parliament's affairs in the first place, are nothing to do with the courts ever, right? But things that are to do with the courts are to be postponed until after the Parliament sessions, and that's what it is. And then they can be, proceeded against and put in prison and arrested, right? But not during. And the best book for that is one of the American books from Jefferson, when he says the reasons why persons who are elected, the electors have the right to have them represent them. But, they did all these recall petition acts and stuff like that. But, yeah, well, that's for in between sessions, really. And, that can still work, to recall an MP during session, in between sessions, right? In between the parliamentary sessions, and then people can get a new MP, but they got the right to have one in through the session time if they're not on Love Island, like Matt Hancock. So